Hello viewers, today's lesson will cover a difference between result crime and conduct crime. We shall also be looking at expert evidence by an expert witness. So brace yourself and get ready for more insight. So for today's lesson, the objective is to understand first the difference between a result crime and a conduct crime. We shall also be looking at how to determine the reliability and impartiality of an expert evidence given by an expert witness. Finally, we should also look at the possible outcome, or we shall also be looking at the possible outcome if one is charged of rape or sexual penetration but happens to be something else, sexual penetration of a child, basically. So we're going to start with result crime. Now, in order to gain a conviction for a result crime, the prosecutor must prove not only that the defendant engaged in the prohibited behavior, but that a specific harm was done. Now, the most common example given is the criminal homicide, or more specifically, murder. The prosecutor must prove that the victim actually died, and he or she must prove that the defendant caused the death of the victim, that it wasn't caused by some other wrongdoer or by a pre-existing fatal condition. So for example, if there is a fatal shooting or stabbing and the victim did not die, then the defendant would not be charged with murder. The victim has to die before the defendant can be charged for murder, because the intended result, which is the death of the victim, must have occurred before we can say the defendant should be charged of murder or convicted for murder. This was demonstrated in Ivan Lee 2018. And now to conduct crimes. To gain a conviction for a conduct crime, the prosecutor need only to prove that the defendant engaged in the specified criminal behavior with the necessary level of fault or intent. So by just engaging in the prohibited act, it is sufficient that the crime has been committed. For example, breaking and entering merely requires a proof that the defendant in fact broke into the structure and entered into it, however momentarily or slightly. The prosecutor doesn't necessarily have to prove that there was any damage that followed after the breaking and entering. So now the question is, had these result or conduct crimes, for example, murder, sexual penetration, or rape? So as I have said a few seconds ago, for murder, the intended result must have occurred before one can be convicted or charged for murder. And for example, sexual penetration, by just penetrating the victim, the child, then the defendant can be charged for sexual penetration. The same applies for rape. It therefore means that murder is a result crime, sexual penetration of a child and rape are conduct crimes. Moving on to the next one. Who calls an expert witness? The court, the prosecutor, or the defense? Now, to the reliability and impartiality of expert evidence. The judge is required to consider a range of factors under the Daubert standard, and these factors include whether the theory or technique in the question can be tested. Secondly, whether it has been tested before. Thirdly, whether it has been subjected to peer review and publication. Fourthly, the existence and maintenance of standards controlling its operation. And finally, whether it has been attracted widespread acceptance within a relevant community. So before an evidence adduced by an expert can be considered reliable and impartial, it must fulfill the said requirement that I just read. And it is normally or a tradition in court that the person who asserts or wants to prove a fact in issue will call an expert witness to provide an expert opinion on a particular matter before the court. Don't forget to subscribe and like. Please comment if there's more videos that you want. Would appreciate if you comment and make some few suggestions.